Good evening, everyone, and welcome to this Tuesday night seminar. Tonight we are joined by Mohammed Haque, who is barrister, or consultant barrister, adjudicator and quantum expert. This is the one of the first in a new series, a case in point live, where Mohammed will be taking a well-known case which changed case law and explaining the decision and everything behind that decision. As always, if you have questions, please don't hesitate to use the Q&A or the chat facility in the bottom toolbar. And Mohammed will get to as many of these as he can at the end. Alternatively, if something you don't wish to ask in an open, please feel free to email him directly. You can see his email address on the screen there, mohammed.haque@fletcherday.co.uk. Okay, Mohammed, it's over to you.
Thank you, Julie. Welcome everybody for joining us this evening with this webinar presentation. It's a new series for us we are doing, and case in point. What we're trying to do here is trying to pick up one of the landmark cases and discuss it a bit more and try to explain what's the net result of this particular precedent. So before I go and explain the case for tonight, I would like to first explain how the English doctrine of precedent works and what's the importance of it. See, I mean, what's the importance of case law in the English legal system? That's something. Of course, if you are from England, if you are from legal background, it's like high school knowledge for you. But there are audience who are attending from overseas jurisdictions, and they might be coming from civil law background where there isn't a doctrine of precedent is there. So they might think, why it's important that a case law be learned or analyzed or looked into seriously. So those of you who are not familiar with or would like to refresh your memory, we are a common law system as opposed to civil law, meaning that the decisions of the higher courts, and especially the point of law regarding the relevant fact and issues of any particular case, is actually a legal rule itself, and it's binding upon subsequent courts, as well as it's binding when we advise clients. So it's not that a doctrinal civil law method that you have a statute which, taking all the facts and circumstances, great judges, they just come to a conclusion, interpret it. But that interpretation, though they are of persuasive authority, has got no legal kind of legal standing. But in England, if the higher court gives a decision, any rule of law they include in their judgment as a basis for coming to the conclusion there, or the remedy they're granting, becomes a binding rule of law for all subsequent matters till it's been overturned. So primarily the higher courts, by the word higher courts, we mean the High Court, the Court of Appeal, and what's now called the UK Supreme Court, and earlier used to be called the House of Lords. So these are the three courts where they sit on appeal, and even if it's a trial decision or a review from various matters in the High Court, that's the first instance court to come to for reviews and trials in many cases. They're binding upon the court's law to them, and they're a persuasive authority for other benches of the High Court, previous or future. And then we are essentially not concerned about a criminal division of the Court of Appeal. Court of Appeal has two divisions. So Court of Appeal decisions are binding on themselves unless one of the exceptions is given in Young and Bristol Aeroplane Company applies. We don't need to go there at all. So they're bound by their own decisions, and all the High Court judges are bound to follow the decisions of the Court of Appeal Civil Division. I'm mentioning Civil Division because we are here dealing with contract matters, which is only a civil matter and dealt with by the Queen's Bench Division of the High Court. And then, of course, appeal lies from the Court of Appeal Civil Division on point of law only of high importance to the UK Supreme Court, and UK Supreme Court is still bound by its own decisions unless they can bring in bring an exception under the practice direction they issued in 1966. So and of course courts below are always bound to follow. However, be you are a tribunal or a court of higher nature, if you can show that the case in hand is factually different, in that case, of course, you don't have to apply the rule, but it still will have a persuasive authority, which is called an every decision. That's quite common in every decision. That includes obiter or passing remarks, obiter, dicta or dictum, one or more, in any judgment will let you know that these, although were not directly the reason for the decision of the court, these were nevertheless part of discussion, or judges felt for one reason or the other, they have to make a comment of. So then they become obiters, and they also are of high importance. And many cases, because the main reason, the ratio, the rationale, or the reason for which the decision was given is sometimes factually narrow. So every time arguments are developed around that, oh, this is an obiter for the current case, this is not the ratio. So, but bear in mind that every single decision of the higher court, and especially Court of Appeal and UK Supreme Court, are of high importance. They're all legal rules, and unless changed, they need to be followed. So that's more or less the basics. Now, the case I'm going to discuss today is, of course, it's obviously, I'm an adjudication person, so it's deal with adjudication. And it's and in adjudication, it's not very usual that a decision will reach up to the UK Supreme Court. Mostly the TCC judges, they are good enough to give judgments and parties accept them. The large body of case laws in last 22-3 years, and starting from jurisdiction and all the types of issues for adjudication proceedings, as this has been either challenged or enforced or attempted to be enforced in the High Court, and the High Court judges sitting as a review judge obviously gave valuable directions, guidance as to what the law means. One thing that we have to keep in our mind, that adjudication business is by and large supported by the English legal system, and it has got to a point that what we see is more and more cases are reaching finality through adjudication. It's from that perspective, it's much less costly if a dispute goes through adjudication, and even through an enforcement or a challenge proceedings up to the High Court, for a value of about £1 million, you get around most something less than 100,000 to spend to get the judgment or complete or finish the whole game. Whereas as a matter of cost, some of it is, if it goes up to the court, some of it is recoverable, some of it is not. party costs are not recoverable before the adjudicator. So yet again, compared to what you may get if you go to the High Court, it's just peanuts. So that's the reason it's getting or becoming more and more popular. And now that very recently we have also started discussing, can we extend this to other type of disputes, or not only construction, other types of disputes. So the core idea right from 1998 is to support, where possible, the adjudication proceedings. And one of the ways of doing so was, of course, that always, in most of cases, unless there's a serious argument on jurisdiction or a serious breach of natural justice, adjudication decisions are enforced. Similarly, if somebody goes to the High Court and says, look, this adjudication shouldn't proceed, it's just happened to me a month ago, and because the adjudicator doesn't have jurisdiction, 9 out of 10 times what happens, the TCC rejects it because the import of adjudication law, section 108 of the Housing Grounds Regeneration, Construction Regeneration Act of 1996, and the scheme allows that the parties to a construction contract, if it's under the Act, can adjudicate any dispute at any time. So it's just that a dispute has to be there, and a dispute is simply defined as any differences between the parties. So as long as it's under the contract, it's very difficult. Now, time to time, people have tried their luck to injunct or gain an injunction to restrain the adjudicator from proceedings any further. I'll just give a few kind of a little bit of explanation of what I'm saying in this. It's simple that injunction is, the whole purpose of an injunction is to restrain someone, refrain someone from proceeding towards doing something. So for simple example, that if I'm making too much noise every day, my neighbor has a right to go to the court and say he should be stopped doing that. Okay, so that's how the injunction remedy works. So in this context, sometimes parties, they go to the High Court of the Queen's Bench Division, the TCC, and then they say, look, this adjudicator has got no jurisdiction to proceed. There's no point throwing money off for this. So please intervene early and give a permanent injunction so that no adjudicator, him or otherwise, can proceed. That's more or less is the attempt been made in this case. What was the ground? As I said, there are various grounds they take, and one attempt, which has been consistently attempted as a ground of challenge or as a ground of restraining the adjudication to proceed further, is that there is another procedure involved for the same dispute, and that procedure should be given preference to the adjudication business. Exactly, that's what has happened here, that the adjudication started by one of the parties, and the other party, Bresco, started adjudication, and Lonsdale started a counter adjudication. At this point, I will give a little bit more facts so that you understand the background. Bresco Electrical Services Ltd was already in liquidation when they started the adjudication, meaning against Michael J Lonsdale Electrical Ltd. So Bresco was in contract. Both of them are electrical contractors, and Michael J Lonsdale, I will refer them as Lonsdale, was the contractor in a project, and Bresco was the subcontractor. So they have a contract between them in which adjudication was available, and scheme was applicable, okay, in that case. So, so all these laws are there to support them. So a scheme was available, and the contract itself clearly stated that the parties have the right to go to adjudicate any dispute under the contract at any point of time. Now, they were in contract, and they were not going well. So what happened? Bresco Electrical, or Bresco, I will call them Bresco in this presentation, decided not to do anything anymore. And at one point in time, they quietly left the site. Okay, Lonsdale was obviously unhappy, and they argued all the way through in this case that they have had to do these works which were not done by Bresco on site, by third parties, and they had to spend more money. So after Bresco stopped coming to, and Lonsdale's taking a view that this is a repudiatory breach, so they said, look, we terminate the contract because you are in a repudiatory breach. So the same thing said Bresco as well, that by some non-action of yours or some breaches, that you were in a repudiatory breach, and we have simply left the site because we have accepted your breach, and it brought the contract to an end. So both parties more or less were saying same thing. And what happened in around June 2018, Bresco liquidators started an adjudication against Lonsdale, claiming about circa 219K for two things: loss of profit and some contra damages. Okay, fine, that's their adjudication. And just after that, Lonsdale started an adjudication against Bresco. Okay, Lonsdale started an adjudication against Bresco that you have left the site, you were in repudiatory breach, and we have accepted it, and we had to spend more money in getting the remaining works done through third-party contractors, and we have lost £325,000. Now, once these cross claims came through, those becomes obviously two adjudications, and Bresco was by then in liquidation. So the insolvency law comes into play, and the new insolvency cross-claim settlement procedure is that as soon as there is cross-claim between a creditor and the company, in this case Bresco, and in this case Lonsdale through its claim of 325, as soon as there is cross-claim between the parties, one thing has to be done that's called net balance accounting. Okay, that means the administrator or the liquidator or the agents will first have to draw an account to find out which party is responsible and how much, who owes how much to whom, and if whichever party has a balance to be paid will become the settlement amount for that type of thing. Now, because both the parties has made or has gone to adjudication, that amounted to two claims, and they essentially become cross claims. As such, the Insolvency Act triggered, and Lonsdale's simple argument was, we claim 325, they claim 219. So what's the point? You know, even if they win, still doesn't make any difference. There's a net balance of 107K. So we better go through the net balancing procedure under the insolvency rule and settle it. So the question was, does an adjudicator, first question, does an adjudicator have any jurisdiction to enter or take a seat as an adjudicator and decide a matter if parallelly the same dispute can be resolved and the proceedings has started under the insolvency law? That was the first question. And the second question, that's the UK Supreme Court, as I'll explain later on, said, or termed as a jurisdiction question. Okay, and the other question was that as the UK Supreme Court has termed it, futile argument, meaning that the second argument of Lonsdale was simple. Even if you win, it doesn't matter because we have a claim of 325, as if they have won the claim. But that was the irony of the matter. But that was their argument, that even if you win it, we've got a 325k claim against you. So in net balance, you're not going to get anything. So why bother? You know, let's go to net balancing settlement discussion and present things to the liquidator or their agents. But the liquidators were saying, look, no, we're interested to go ahead with the adjudication, and you go ahead with your adjudication as well. If you lose, we win. Obviously, that's the best scenario for Bresco. Even if both wins with the same quantum, that means they get 219, they get 325. That also means the net balance is very easy. It's just 106k. That's no net balancing procedure needs to be involved. You know, adjudicator's decisions are binding upon unless arbitrated or going to a court for a final settlement. So that's the idea. Okay, that's the idea, and that's the reason why Bresco, Lonsdale went to the TCC saying that this should be stopped. Okay. Interestingly, the TCC judge has endorsed both points of Lonsdale. He took a pragmatic view, and he thought that since there is overlaps here and one is incompatible with the other, it's preferable that the adjudication be stayed till the net balancing procedures come to an end. And he took also the view that he thought it's actually a good argument that there will be a futility, because even though an adjudication decision is pronounced, it won't be enforced till the net balancing accounting procedure comes to an end. So why bother to adjudicate at this point? Do you find any problem? I did. When the High Court judgment came in, I did. I thought this is absolutely wrong. With all due respect, he's a High Court judge and I'm only an adjudicator. What's the problem? The problem is, A, that the statute says that you can refer to any dispute under the contract at any time. Okay? Any dispute under the contract at any time. Now, solvency is maybe construed as not a proceedings under the contract. It's under a company matter rule. Maybe, that's one thing, okay? But if contract says something about insolvency, that argument doesn't occur. The second thing is there any indication within the statute that this enormous, this wide, this extended power to adjudicate any dispute under the contract at any point of time, provided that it can be established that there was a difference between the parties, and it is parties either agreed or it's under the Act, under the Act and adjudication is allowed. In that case, is there any proviso, any condition, any restriction mentioned within the Act? Or the Act says that you can add a procedure to adjudicate if it's a construction contract which is compliant with the Act. If it's not compliant with the Act, the tiny little fault in it, the scheme for construction contract will come in place for dealing with the procedural issues and the powers of the adjudicator. In any case, the contract complied with the statute and section, the first section of the scheme, that the parties can go to adjudication with any dispute under the contract at any time, was actually repeated, just like borrowed from the scheme and added to the contract. So that's a wide power. Unless the parties, even if it's a contractual issue, unless the parties have decided to restrict their fate for a statutory and other proceedings of net balancing exercise under the Insolvency Act, where is this power to stop coming from? And I've already stated, for the futile argument, it kind of presupposes that Lonsdale is going to win the adjudication. What if Lonsdale doesn't? What if both of them wins? Or what if Lonsdale wins half of its money? You know, why would that be a futile? Well, even if it's futile, it cannot be enforced till the net balancing is complete. We can wait for enforcement, but why would that be a reason for not enforcing or not allowing the adjudicator to proceed? It could be common sense, but the statute doesn't say so. Okay, so I had this doubt. Anyway, and that's the reason, well, House of Lords or UK Supreme Court concurred with my view eventually. But coming to the point, of course, Bresco was dissatisfied and it went to the Court of Appeal. Court of Appeal, Civil Division. Yeah, I'm dissatisfied. You need to seek a leave. Procedure is either you seek the leave from leave meaning permission, if you're unfamiliar with that legal term, to appeal to the Court of Appeal Civil Division, to the judge who was deciding your case. If he refuses, then you have a right to go to the Court of Appeal itself and seek leave. And one way or the other, Court of Appeal Civil Division has picked up the case, and Court of Appeal agreed 50% with me, okay, that yes, the earlier decisions of this court or the courts below, and especially they referred to a decision of Lord Justice Aikenhead. He was a judge of the TCC, a remarkable judge of the TCC, did wonderfully well, delivered very good judgments. He decided not to pursue his career at the TCC to become a full-time international arbitrator. That's when he was retiring, and the last time I met him as well. So he, relying on one of his decisions and explanations he provided as how wide the power is, and there's no reason just because it overlaps with something else to prefer that something else, because adjudication is an interim remedy to solve cash flow issues, and who else needs it more than a company in liquidation to solve its so obviously its cash flows. So all these actually caused the Civil Division of the Court of Appeal to say that the jurisdiction issue is actually not a proper one. The adjudicator did have jurisdiction, but then they took a policy type decision that nevertheless you cannot take out the insolvency settlement procedure either. Net balancing would be required, until that net balancing comes to an exhaustion through a net balancing arbitration, the interim decisions of the adjudicators cannot be and will not be enforced. So, so the view was that they still think that adjudication shouldn't be proceeded, and they preferred to issue the injunction. Okay, that's, although the first point gone as per them, but nevertheless they took the view that the next point is very highly philosophical. So we are here to take a pragmatic view, and they have supported Lonsdale. Poor Bresco appealed, and again can only appeal to UK Supreme Court if you have a point of law of high importance. Now, on one hand, the Act, the Construction Act, Housing Grant Construction Regeneration Act, I've just mentioned the name, the Act, allowed the sector a wide power. You know, it allowed interim payments, and also it allowed the parties to go to adjudication at any time. It's a very, very wide power, and it's so very helpful, and it helped our industry so much. So, and as I say, increasingly more and more disputes are reaching finality just after going through an adjudication, at the most an enforcement or a challenge proceedings in the High Court. So it's now the preferred mode. Arbitration has died literally for adjudication in England and Wales in construction. So so these are all the reasons which actually helped Court of Appeal to think that no, jurisdiction is not an issue here. Adjudicator has the right to, but then they took a pragmatic approach, a futile thing that what's the point? What they were doing, in other words, what they were saying was, what's the point of having the decision if you can't enforce it? So it's better that you don't have a decision, right? Bresco appealed to the UK Supreme Court, pleading that it is of high importance that overlap with or conflict between one statute, and in particular the Act with other acts in granting proceedings for specific situations like this one. The other one should be preferred, and the Lonsdale argument, as it was either due to jurisdictional issue or due to a futile argument, it should be stopped once and for all. UK Supreme Court thought it is of importance. It did creep up earlier on other cases, so they thought, okay, it's a good time to think about the conflicts of similar sort. And of course, Lonsdale also did a cross appeal. They appealed against the decision of the Court of Appeal's Civil Division, because obviously Bresco didn't want that point to be discussed at all. They only was trying to sort of knock down the futility point, but Lonsdale came back and said, look, we are also appealing against that decision of the Court of Appeal where they say that the adjudicator did have jurisdiction. So this has actually not only become a cross-claim situation, this became a cross-appeal situation before the UK Supreme Court, okay? It was heard on 17th and 18th of April 2020. I was waiting for the final interview for me to become an adjudicator for the President's panel. It was supposed to have happened earlier, but due to COVID, it was delayed. So I was waiting for the final interview, and then it reached this. We had earlier sessions, and we all knew that the question would come. And anyway, the day the UK Supreme Court handed over the decision, I had my, or even not handed over the decision, I actually watched some of the proceedings live. Pandemic, I was sitting at home anyway, and doing some adjudication. But yeah, and my ex-mentor said, "No, be ready, because you'll be quizzed on this." So I thought, okay, I'll have a go, and I'll try to champion the answer, and it's an opportunity to impress my board so that I'll become President's main panel adjudicator, where I was not a full member. But so much to my delight, His Lordship, Lord Briggs, handing the judgment, leading judgment, all the other law lords, including the President, Lord Reed, concurred and unanimously said that UK adjudicators, we want to clap you, we want to support you. So there's no jurisdictional issue here. The power granted by the Act is so wide that it doesn't matter that other statutes has other proceedings. As long as you fulfill the requirement of the Act, it doesn't matter whether the party you are claiming against or for is in liquidation. It doesn't matter at all. You'll be allowed to go to adjudication. In their words, we read through the Act in the scheme. There isn't anything within the scheme which says that if there is an insolvency proceedings in place, they'll be acting as a restriction or a limitation to the otherwise available wide jurisdiction granted by the Act to the adjudicators. And secondly, the Supreme Court took the view that, well, we don't have to be pragmatic. These are two different questions altogether. One is decision of the adjudicator, and the other is its enforcement. The enforcement may be delayed. In normal cases, usually you've got to try to enforce it ASAP, and that's done anyway because the parties are desperate to get some cash out. So whoever wins, they jump in to sort of enforce it, or the other party tries to challenge it. But in cases like this, the decision can wait, to be enforced. But that does not or cannot be a ground for restraining the adjudicator from proceeding further. So imagine if a decision was given and then a party goes to the High Court, what would have happened? Every time it's happening, that the court is saying, pay first, argue later. You first pay. Imagine Bresco won the 219K. The 325 claim has not come up with a decision yet. They jump in and go to the High Court. TCC, I would say, okay, you at least ring fence 219, keep it in an account, and then adjust it with your net balance if you win your adjudication at the most. Or most likely decision would be, why don't you pay now? Why don't you pay now? You will be adjusting it later on, and then the court can direct the liquidators to keep it ring fenced. Simple solution. Why do we have to stop the adjudication to go ahead? Poor me didn't find a logic. UK Supreme Court didn't find a logic. So they have supported as they have been, and that's the case is all about. Adjudication, no matter what you feel, is something available at the hand of the parties who are doing a construction contract. I think that's all from my side. There are questions.
Okie dokie. If anyone has any questions, now is the time to pop these over to Mohammed. In case you have any questions about that case there, obviously you've got the full case title there, so if you want to look up more details of what Mohammed's been talking about tonight, you can do. Otherwise, we will see you, Mohammed, again on Thursday.
Well, I mean, just to give an answer to Hossam Farhach. I see you have already given it.
Yeah.
The whole judgment is there in our website. In case you can't enter the website, just Google it.
Yeah.
Wherever you are,
Everything can be good.
wherever you are, just Google it, you get the judgment. And
Yeah,
also,
got the full
always go to Bali, British Irish Legal Decisions, they publish all the decisions, important decisions, so that's the answer. All right, then.
Okay.
That's it.
Lovely. We're back with you on Thursday, Mohammed, because we are talking to you of the latest in your changes in construction contracts for the valuation and other implications. That's at 6 o'clock on Thursday. And tomorrow morning at 8, we have John Sharp with effective delay analysis, tools and techniques. So if you'd like to place on either of those, please email us seminars@fletcherday.co.uk. Otherwise, it just remains to thank you all for turning up. Thank you, Mohammed, for sharing your wisdom with us yet again. And we will see you soon. Take care.
Bye.
Bye-bye.